don't usually do half.
5 minutes?
That'll be
Okay.
fine.
5 minutes.
If we do half, that pretty much flips as to who's appellant and
I
who's.
thought that might have been the rule, and I didn't check
It never hurts to ask, does it?
So before I talk about why the trial court erred in finding negligence on behalf of the Baskins and also in awarding damages, I want to point out 4 key points about this case that I think demonstrate what an anomalous and improper result the trial court reached. One, the trial court found that this hole in the yard was a sinkhole. The trial court refers to it as a sinkhole several times in the opinion, bases the award of damages on the fact it's a sinkhole. But the trial court acknowledged it was not a sinkhole under the Tennessee statute that requires a sinkhole to be disclosed in a disclosure statement. And the trial court also found Mr. Baskin liable for this sinkhole. The trial court correctly found that Mr. Baskin had no duty to disclose the existence of a sinkhole on the Tennessee Residential Property Disclosure Form because there was no sinkhole indicated on a recorded plat map, which is the standard in the Tennessee Residential Property Disclosure Act, which has been set by the General Assembly. The trial court also found correctly that Mr. Baskin did not know that it was a sinkhole, even though he was held liable for it. The 4th point that I would like to make that I think is important is there was an as-is clause in the contract between the Baskins and the Bakers. And in fact, when the Bakers bought the property, they were warned you should go have a geotechnical engineer determine whether there's a sinkhole on this property, and they elected not to do that. I'd like to engage in, if the court will indulge me in a hypothetical that I think is helpful. The Bakers hired a geotechnical engineer named Mr. Mishu, who came in and he testified this was a sinkhole. If, when Mr. Baskin discovered this hole, he would have called a geotechnical engineer, if he would have called Mr. Mishu, and Mr. Mishu would have come out and said, that's a sinkhole, Mr. Baskin still would have had no obligation to disclose that on the Tennessee Residential Property Disclosure Statement because that was Mr. Mishu's opinion. It is not a sinkhole as indicated on a recorded plat map. Yet he's found liable. I mean, under that hypothetical, he would have still been entitled to check, no, there is no sinkhole on this property. There is a question in the disclosure form about, are you aware of, quote, other soil problems, period, close quote, to which Mr. Baskin checked no. And what I'd point out to the court is that residential property disclosure statement uses the present tense. It asks the person who's filling it out, are you aware, present tense, are you aware of any soil condition? Mr. Baskin was not aware of any soil condition because he'd fixed this hole, which was a small hole when he found it some 6 months earlier. In the interim, he'd driven over it multiple times with his 500-pound tractor. It didn't even concave. Mr. Baskin did the same. When he bought the house for about, I think, 4 months, he cut the yard with his 500-pound mower, never noticed any problem with it. It didn't concave, it didn't indent. He only discovered it when he got out digging in his yard. So, and I would say that if you're not going to limit a homeowner's disclosure of a defect to what that homeowner is currently aware, where does it stop? If you have a repair done to the electrical in your home and it was a year past, you have to identify that on a residential property disclosure statement because after all, you've had an electrical problem, even though you might have had no problems with it. And that's what happened with this hole. He had no present awareness. He believed he had adequately fixed this hole. So let me talk about why the trial court's finding of negligence was improper. And it's also a very anomalous finding because here's what the trial court faulted Mr. Baskin for. After finding he did not violate the Tennessee Residential Property Disclosure Act and did not commit negligent misrepresentation for failing to disclose it, the court faulted him for, quote, no further investigation or repair of the hole. And the trial court said that created a foreseeable risk for personal injury and property damage. That's what the trial court faulted him for. Now, the trial courts in the same paragraph it's an anomalous conclusion because the trial court says, but he breached his duty by failing to disclose the whole, after already finding that he was not liable for, under the theory of negligent misrepresentation, for not disclosing the whole. And what's critical is there was no damage caused by Mr. Baskin not doing any further investigation or repair of the whole. Nobody was hurt. The structure wasn't damaged. So if the tort of negligent misrepresentation didn't exist and all we had was negligence, he would not be liable for negligence in this instance because there was no damage, which is an element of negligence.
But the diminution in the value of property, would that not constitute a damage?
If there was diminution in the value of the property, it would be damage, but not because of Mr. Baskin. It would be because the sinkhole existed. Mr. Baskin did not cause the sinkhole. There's nothing he did in failing to repair or further investigate it that caused any additional diminution in the value of the home. So the diminution in value would be damage, but it was the sinkhole that caused the diminution in value, not Mr. Baskin's alleged failure to further investigate it or repair it adequately.
And your position is because the sinkhole was not on a recorded plat, there was no duty to report a sinkhole?
There was no duty to report a sinkhole because it was not on a recorded plat. So the
He put it, am I correct, that he pushed to the 4x4, 5-foot long wooden post into the hole
yes, Your Honor, you're
by
correct.
hand?
You're correct. He pushed two. They're actually three. They call them 4x4s. They're 3.5 by 3.5.
Yeah.
He pushed two of those into the hole, and he said he couldn't remember whether they went on top of each other. They went side by side. Now, when Mr. Baker discovered them a year later, he said they were wedged in there quite tight. The post that he found was wedged in there quite tight. So even if there was a material defect, and we say this was not a material defect because once you repair something that, and there was no proof in the record to refute Mr. Baskin's testimony that the biggest he ever saw that hole, now he didn't know the depth, but the widest he ever saw it was, I think he said 3 inches. There was nothing to rebut that. I know that there was later testimony that when Mr. Baker discovered it, he first said it was a very small hole, and then when he pulled the post out, it opened up to about 1.5 feet. So our position is there was no material defect. Even if there was, Mr. Baskin had no duty to disclose it. That's just black letter Tennessee law. You only have a duty to disclose in 4 circumstances. If there's a previous fiduciary relationship between the parties, which there was not here, if one party reposes trust and confidence in the other, there was not that. If the transaction was inherently fiduciary, there was not that. And then we've got kind of this, I view it as an outlier, this restatement of second provision that if it's a, quote, fact of controlling importance or a fact basic to the transaction, which is different from a material fact. And this hole met none of those criteria. The court found it was a material defect. The court did not find that it was a fact of controlling importance, which is a critical distinction. And we submit there's no proof to find it was a material defect, and there sure wasn't enough proof to establish that it was a fact of controlling importance. The trial court's relying on negligence as opposed to the proper tort, which would be negligent misrepresentation, allowed the Bakers to totally escape proving justifiable reliance. And there was an as-is clause. And we've cited the case law to the court that if there's an as-is clause, unless you engage in some kind of trick or contrivance, you're off the hook. And the trial court found that there was no finding that Mr. Baskin engaged in any kind of trick or contrivance. Lastly, Your Honors, there were just no damages proven. Mr. Courtney's testimony was held inadmissible by the trial court and then held inadmissible for the purpose of proving market value and then relied upon by the trial court to prove market value. We'd also say even if his testimony had been admissible, if he was qualified, which he admitted he was not qualified to opine about market value, his opinion was totally conclusory. He had no comparables for a home with a sinkhole, had never sold a home with a sinkhole, and admitted that he didn't base his opinion that the home was worth less because it had a sinkhole on anything objective. Mr. Baker, the trial court also relied on Mr. Baker's testimony. He just simply testified the house was worth $55,000 less because of the sinkhole. That was it. There was no mention of a comparable. There was no mention of any experience he had with real estate.
Well, isn't a homeowner entitled to testify as to the value of the home?
They are, Your Honor, but
So,
yeah, but Tennessee case law says it can't be purely conclusory. You've got to have some evidence. You can't just get up and say, I own the home, therefore I believe it's worth $55,000 less. And there's several Tennessee cases on that point. And there's several Tennessee cases where the homeowners offered less proof than Mr. Baker offered. In one case, the homeowner even offered testimony about comparables, but the court found that those comparables weren't in the same neighborhood, as I recall that case. So you're correct, a homeowner can, but that can be misleading because you can, but you can't just get up and say, because I'm the homeowner, you have to accept this value. And that's exactly what happened here. He just simply testified as
you
well.
don't have to accept you don't even have to accept an expert's value. So, you certainly don't have to accept the homeowner's value. But I was just thinking about testifying as to what it was worth.
He can certainly do that. He's certainly entitled to testify. Even assuming that all that testimony was competent, a major problem with it is all of it was about the diminution value 2 years after the transaction in 2019, not in 2017. That's when you're supposed to determine the diminution value.
You have your time for rebuttal.
Thank you, Your Honor.
We'll hear from the appellee.
Good morning, Your Honors. Jean Harrison here on behalf of the Bakers. Sorry, I'm losing my voice. This case is an oddity, and I'll be the first to admit it. I've been a construction lawyer for going on 30 years, and this one has all the weird boxes checked for me. It's absolutely true that at the time that this case was, when the house sold, that 665212 defined a sinkhole for purposes of disclosure as one that is shown on a plat map. This particular property is in Donaldson. It was built in the 50s. There wasn't a plat map. It's undisputed that there was no recorded sinkhole on the plat map. Can't argue with it. I will point out to the court, the legislature has changed this law since this went into effect, and that recorded on a plat map language isn't there now. Doesn't help in this case, but it is worth noting that that has changed. The simple fact of the matter is this was a sinkhole. You can call it what you want it, but call it a dropout, call it a hole, call it what you want. It's a sinkhole. It is a karst feature. The court essentially, I think, was attempting to say it's not a sinkhole for purposes of the Residential Disclosures Act, but it's a sinkhole. The sinkhole is in front of the house, directly in front of the house. And the testimony is undisputed that Mr. Baskin found the sinkhole and put 4x4 posts into the ground trying to fill it up. The reality of it is that it's our position and it was the court's position in this case, that this hole was a hole it was a material fact. It was something that mattered to a homeowner that should have been disclosed, whether it's defined as a sinkhole or not. The purpose of the Residential Disclosures Act and all of the disclosure requirements that come with this is that you're supposed to inform people about the condition of the property.
Well, it's certainly material in hindsight.
Correct.
But when Mr. Baskin found it, he didn't think it was a big deal, did he? Or did he? I mean, what was his testimony about it? Was it I just thought it was a little hole and I filled it up? And is that credible given he had to put 2 4x4s in it?
Your Honor, respectfully, I think his testimony was twofold. Number one, he said he found it while he found a depression while he was mowing the lawn, went over, and, I don't know what was in Mr. Baskin's mind. I'm not capable of retroactively.
There was no
Into-
testimony. No, I understand
But
that, but let's
as
stick
a-
to the record. Does the record talk
The
about it?
record talks about that he found it, and that, he was asked, why didn't you do something? Why go grab a 4x4 post? Because frankly, I found that odd. Normally if you find a hole in the ground, you go for a bag of soil or something. You're not running to grab a 4x4 post and put it in the ground. And the fact that he put 2 in, Your Honor, to me is just evidence that this was not a normal occurrence where a normal situation, somebody finds a depression and they fill it. Instead, this gentleman went for 4x4 posts and wedged them into the ground, covered it with, a bag of soil, and then planted grass over it, and then a couple months later put the house on the market. Those are the facts as they exist. Obviously, Mr. Baker, the following year when he bought the house, he was following the gas line around, and the testimony was that he discovered this because he was getting ready to dig up the bushes in front of the house and had utilities marked and saw a gas line that somebody had bootlegged at some point in the past, and went and dug it up and found this, and then the hole collapsed. And that is, I think, the sequence of events that occurred here. The issue before this court, and again, this is, and I concede it's a strange opinion from the chancellor in this case. I think she was attempting to reconcile 2 people that she found to be credible, and I understand the difficulty. But the reality is, to take this in some semblance of order, the sinkhole, whether it's indicated on a map or not, it's a hole in the ground, and you put 4x4 posts in the ground. And if I'm buying a house and a normal person's buying a house, that's something that you would want disclosed. The point is, the duty that you have when you are engaging in a contract is one of perfect faith. You've got to tell people things that they are not capable of ordinarily discovering it. And Chancellor Moskal found that this was not something that the home buyer could have discovered on their own. I mean, yes, it's true that in the million papers that they came with the sale, that it does say, well, you could get a geotechnical inspection, but respectfully, Your Honor, no one does that unless there's a reason to, because if you called out a geotechnical engineer, what are you gonna do, LiDAR to check for this? It's not a practical thing that people do. You do geotechnical inspections for commercial work, you do geotechnical inspections if you have a reason, but absent some disclosure that there's a potential reason to do it, if you're looking at a home with a lawn, normal people don't get a geotechnical engineer. So, that to me is unavailing.
Ms. Harrison?
Yes.
I want to talk about the as-is purchase, but before that, I'm having difficulty understanding how failure to disclose a hole in the backyard as being an act of negligence.
Okay.
How does,
Well,
I think of negligence in a different context.
Let me see if I can explain this the best I can, and I understand the court's difficulty, and I think I understand Mr. Pepper's difficulty, because I have my own. But let's start with the as-is clause, because that, I think, is part of this. There is an as-is clause that came not with the original contract, but with the repair contractor accepting it as is. Those are very standard. And it just says you're agreeing that this has been done. In the context of a negligent misrepresentation claim, an as-is contract will defeat a negligent misrepresentation, and we concede that. But what we're getting at here is that the as-is clause doesn't apply, because this, based on the findings that the court made, this actually rises to the level of concealment or gross negligence.
I'm sorry, rises to the level, did the trial court find either of those?
No, and we appealed on that, Your Honor, because we think that the trial court was inconsistent there, because you can't have the findings that she made, that there was a hole that he covered up that he had a duty to disclose, but didn't, and it was a material fact. So again, our point there, Your Honor, was that that was factually inconsistent with the legal analysis that you would apply to a misrepresentation or a gross negligence standard. But with regard to your question about negligence, what she essentially found was that, let me see if I can read this. I guess in order to prosecute a negligence claim, the standard has always been that there's a duty of care that's owed by a defendant. That's number one. There was a duty here to, as you know, to the extent that you have a contractual obligation to disclose what you know, that is a duty that we would contend that they had. The conduct of the defendant fell below the applicable standard of care. Well, if you've got an obligation to disclose material facts, as in the Patel case and the related, and that whole, and you know, the case law that comes down from that line, if you have an obligation to disclose that and you don't do it, that's your conduct that fell below the standard. Third was the injury or loss. Briefly, I'll discuss this. Mr. Pepper took some exception with the testimony about damages. What he didn't say is, number one, there was a stipulation as to an appraisal by Mr. Huber as to the value of the property at $380. The property sold for $325. That is how the $55,000 came. It was put on the open market. Mr. Courtney, who's with Friedrich and Clark, has been for 40 years, testified that, yeah, he's not an appraiser and can't give an opinion, but he gave a real estate broker's opinion as to value. They put the house on the market at $379, independent of Mr. Huber's subsequent finding of value, and the house sold for $325. That's diminution in value. And then Mr. Baker testified that it was worth $325,000. The diminution value is the loss that was caused on the negligence side of it. Causation, in fact, and legal causation, you know, I've gone through that in the brief, but essentially, the causation, in fact, on this is, of course, it's fact sensitive, and the court has gone through that analysis as to how she did it, but basically, but for Mr. Baskin's conduct in covering up the hole and failing to disclose it, Mr. Baker would not have bought the house. Mr. Baker testified that if he had known, he wouldn't have done it, and that any injury, so basically, with regard to proximate cause, an injury that is the natural and probable consequence of an act is actionable, and that, and if it could have been foreseen, which she said it was foreseeable that this would happen, that there would be a subsequent collapse. That's how she got to the negligence standard. There is no requirement in the negligence standard that there be some sort of trigger contrivance, as was suggested by Mr. Pepper in his briefing. It's just simply that for purposes of negligence, that's the analysis she used. The appellee in this case, Mr. and Mrs. Baker, submit that the court where they got it wrong was that in making the findings that she did, that he covered this up, that he should have done it. By having made those findings a fact, if you apply the law and the standards relevant to gross negligence and to concealment, she should have found that there was concealment and that there was a gross negligence on the part of the Baskins for that reason. Because you can't make the finding that you deliberately, you know, I guess deliberate is a loaded word, and I understand, but he made the conscious choice to put 4x4 posts in the ground, to cover it with a bag, and then plant some grass and move on and sell it a couple of months later. The logical conclusion is, if you're going to make the finding, as the court did, that conduct occurred and it should have been disclosed, but it wasn't, that's a concealment, and that takes you outside the ambit of the as-is, which you had earlier asked.
I'm still confused, though, as to the as-is. Is it your position that even though the contract is an as-is, that the seller still has the obligation, assume the seller knows these things, the seller has the obligation to tell everything they know, even if it's an as-is contract?
Yes, the case law is crystal clear on this.
What's the purpose of the as-is?
The as-is only applies if you are talking about negligent conduct. When you are concealing something, or you have covered up something, that takes away.
So the as-is would apply to just negligent conduct, which is what the trial court found?
I guess the trial court, and this is the oddity of the opinion that we're all struggling with, the trial court found that there was an as-is, which meant that negligent misrepresentation didn't apply, but negligence did. There is no, the as-is clause doesn't have, as-is is a contractual thing, I guess, is her logic, as near as I can tell, and the as-is would do away, wouldn't apply to negligence in her view of the way that shook down. That's the analysis I took away from the court's opinion. As-is in tort law, or in contractual issues, if you sign a contract and you have as-is, but you've concealed it, the case law is crystal clear that you can't hide behind an as-is, because if you've gone to the trouble to conceal it, then the court's not going to uphold an as-is clause because you failed in your obligation to do this. So you can, I think the court sees the issue that we're all dancing around in this particular instance. But the short version of it is, if I go back to the gross negligence, we had submitted to the court that the proof showed that Mr. Baskins was grossly negligent, and the standard is a conscious neglect of duty or callous indifference to the consequences. And respectfully, the Baker submitted that this was an error that the chancellor made, largely because of the specific findings that she made. He put 4x4s in the ground. He put soil on top of it. He covered it with a plastic bag and then planted soil, so that's fact one. The hole wasn't visible after it was covered, and Mr. Baskins knew the hole was deep, but he didn't know how deep it was. Then he listed the property for sale within 6 months, and he didn't disclose any defect or soil problem relating to the hole. The disclosure, on the disclosure, he said that he thought he had fixed the problem, but it doesn't matter, and I want to be very clear on this. The Disclosure Act, if you disclose, even if you've repaired something, you're still required to disclose it. You have a place where you can make notes about what you did.
That was the example opposing counsel gave. If there's an electrical problem
That's correct.
and it's repaired,
Then you because the
you have,
disclosure forms say,
under your position, you have,
yes,
so everything, if you've had the house for 30 years, every repair you've made to the house, you have to disclose.
if it falls within one of the enumerated categories, and those enumerated categories include walls, ceilings, floors, roof, soil, flooding, drainage, very specific things.
That pretty much covers the house, doesn't it?
It does, and yes, you are
So,
required.
so the answer to my question would be, what would be yes?
Yes, you're required.
You go back however long you've had the house, if you made a repair.
Respectfully, I think the last time I sold a house that I'd been in for a long time, I had done, got hit by the tornado, and so there was a million things that had to be disclosed. It had been repaired, and the way that the way that you normally do that is provide an engineer's report or a brief description of what was done. But yes, Your Honor, that's the law. The
Do
residential.
you have any cases that
It's the
goes back like that, in which one says, the law is that you have to list every repair you've made to the house before you sell it?
The form says it explicitly, Your Honor, in the statute directly. If you look at 665201, it explicitly spells out what you have to do. And there's actually a form that's provided that specifically says that. So, yeah, it's annoying for homeowners, but it is, the current
It might
standard.
be more than annoying, it might be pretty scary.
And your position is the Disclosure Act applies even with an as-is contract?
To the extent that you have knowledge of a material adverse fact that yes, you must disclose it. Thank you, Your Honor.
Thank you. Here from the appellant rebuttal.
Technology and electronic pens.
Your Honors, I think what Ms. Harrison has just conceded is really important. Basically, she's conceded that to affirm the trial court on this negligence claim, there's now got to be a finding of gross negligence. That's what I hear her saying. The other thing I would say is there was no stipulation that Mr. Huber's appraisal set the value of the home for purposes of damages. We stipulated that it was admissible in evidence. There were reasons other than the fact that of his appraisal, there were pictures in that appraisal, there were other things that I understood they wanted to get in, but that stipulation very specifically says it's just admissible. It doesn't say that the Baskins have agreed that it sets the value for purposes of determining damages. Judge Bennett, to your point about, the possibility that maybe Mr. Baskin wasn't credible about this hole because he put 2 posts in it, I would say the trial court expressly found Mr. Baskin to be credible. And I would also point out that this hole was by a tree which had been removed, and Mr. Baskin thought that was a rotting root. In fact, when Mr. Baker discovered the hole, that was the first thing he thought it was. He thought it was caused by a rotting root. And that's just the kind of problem that I would submit a homeowner. The first thing you would think is not, I need to call a geotechnical engineer. The first thing you would think is, well, that tree had a big root and it's rotted and now got a hole. Might people have done it differently than putting 2 posts in the ground that were, he did say that they were pressure treated, and he understood those to be insect resistant. And people might have done it differently, but he believed he had repaired the hole. And I'd also say the bottom line is, this case is that Mr. Baskin complied fully with Tennessee law. There was not a sinkhole, as shown by a recorded plat on this property. And yet, then an expert witness comes in and says, well, by gosh, it is a sinkhole. And the next thing we've got is Mr. Baskin's being held liable for a sinkhole, because the trial court, even though the trial court said at one point it's confusing that Mr. Michie's referring to as a sinkhole, the trial court found it was a sinkhole, and found that based on Mr. Michie's testimony, it compromised the integrity of the house and could have caused personal injury and all these other things. So that's all I have, Your Honors, unless you have questions.
I
Thank you
hear
very
none.
much.
Thank you. Our thanks to counsel, both sides. We appreciate your arguments today and your briefs.